Most people assume that for nearly all of history, marriage was a one-way door. A woman walked through it once, and there was no walking back out. Not without scandal, ruin, or worse. The actual legal record tells a much stranger story. In some ancient societies, divorce wasn't just possible. It was easier, faster, and less socially catastrophic than it is in some parts of the world today. For most of human history, marriage was never the uniform, permanent, unbreakable institution it's often imagined to have been. It was a legal contract, and like most legal contracts across most of recorded history, it came with an exit clause. Though the size of that exit, who could use it, and what it cost varied enormously depending on the century, the country, and above all, the legal system a person happened to be born inside of. This video traces the actual legal record of divorce across roughly 4,000 years and 5 separate legal traditions: Mesopotamian law, ancient Egyptian practice, Roman law, the medieval Christian legal shift that closed the door those earlier systems had left open, and the parallel Jewish and Islamic legal traditions that kept a version of that door open through the exact centuries European canon law was sealing it shut. What emerges isn't a simple story of progress, primitive restriction slowly loosening into modern freedom. It's closer to the opposite in several specific well-documented cases. Legal systems thousands of years old that handled divorce with a bureaucratic ease that would look almost unremarkable by modern standards, followed by a specific traceable historical moment when that ease was deliberately shut down, for reasons that had very little to do with morality and a great deal to do with theology and property law. This video draws on legal history spanning multiple continents and legal traditions from cuneiform tablets, inscribed nearly 4,000 years ago, to parliamentary records from 19th century England, and the comparative legal scholarship that has translated, cross-referenced, and analyzed all of it. None of what follows argues that any of these historical divorce systems were straightforwardly fair or equal. Several documented asymmetries between what husbands and wives could legally do will come up directly. The claim being traced here is narrower and, in its own way, more surprising: that the specific idea of marriage as legally permanent and essentially unbreakable, an idea many people today assume is the ancient traditional default that modern secular law gradually loosened, is itself a comparatively late historical development, arriving centuries after several much older legal systems had already worked out detailed, codified procedures for ending a marriage. Begin in Mesopotamia, because this is where the earliest known written law codes addressing marriage and divorce survive. And the picture they present cuts directly against the assumption that ancient legal systems locked women into marriages with no exit at all. The Code of Ur-Nammu, the earliest known Sumerian law code, compiled under the ruler Ur-Nammu of the 3rd dynasty of Ur in Mesopotamia, in the region of modern-day Iraq around 2100 to 2050 BCE, contains some of the oldest surviving written provisions addressing divorce anywhere in the archaeological record. Assyriologist Martha Roth of the University of Chicago, whose translations and analysis of Mesopotamian legal texts remain foundational to the field, published extensively, including her 1995 compilation Law Collections from Mesopotamia and Asia Minor, has documented that Ur-Nammu's code specified a fixed monetary payment, 1 mina of silver, owed by a husband who divorced his wife, a remarkably concrete, transactional approach to what modern audiences might expect to be handled as an unregulated matter of personal or religious authority, rather than codified civil law. Roth's research places that 1 mina payment in useful economic context, since a bare number on its own says little without a sense of scale. Comparative analysis of Mesopotamian silver values from the same period, which Roth's broader work on the legal corpus addresses alongside her direct legal translations, suggests a mina represented a genuinely substantial sum relative to typical household wealth of the era, enough to function as a real financial deterrent against casual or impulsive divorce while still leaving the option legally and practically available to a husband who was determined to exercise it. That combination, a real but not prohibitive cost, recurs across nearly every legal system this video goes on to examine, suggesting an underlying pattern worth naming. Early, very few of these ancient and medieval legal traditions treated divorce as something to be made either completely free or completely impossible. Nearly all of them instead built in some form of friction, financial, procedural, or both, calibrated to discourage impulsive dissolution without fully closing off the option. That detail matters immediately because it establishes something worth carrying through the rest of this video. Divorce, in Mesopotamian law, wasn't treated as a moral catastrophe requiring justification before a religious body. It was treated as a civil transaction with a defined legal procedure and a defined financial cost, tracked and enforced the same way a property dispute or a debt would have been. Move forward roughly 3 centuries to the Code of Hammurabi compiled under the Babylonian king Hammurabi around 1754 BCE and preserved on a diorite stele discovered by French archaeologists at the site of Susa in modern-day Iran. In 1901, now held in the Louvre in Paris. Roth's analysis of Hammurabi's code documents an even more detailed set of divorce provisions than Ur-Nammu's earlier code, distinguishing between different circumstances and assigning different financial consequences to each. A husband divorcing a wife who had borne him children was required under specific provisions Roth's translation documents directly to return her dowry and provide for the children's support. A wife found to have been, in the law's own terminology, a poor household manager faced different and generally harsher financial terms if her husband chose to divorce her. Critically, Roth's research also documents provisions under which a wife herself could initiate the end of a marriage under specific legally recognized grounds, including cases of a husband's cruelty or neglect, with the law assigning financial consequences to the husband in those cases rather than to the wife. Roth's translation work identifies specific numbered provisions within Hammurabi's code, addressing exactly these scenarios, among the roughly 280 surviving provisions inscribed on the stele. The code specifies that a husband who wished to divorce a wife who had not borne him children still owed her a specific silver payment, roughly equivalent to her original bride price, establishing a direct calculable financial cost attached to the act of divorce itself, regardless of fault. A structural feature Roth's broader analysis connects to the code's overall approach to civil law, which consistently favors specific, numerically defined penalties and payments over vague or discretionary judgment. That same numeric specificity extended to the provisions protecting a wife divorcing an abusive or negligent husband. Roth's translation documents language allowing a wife to take her dowry and return to her father's house if she could establish the husband's fault. With the husband barred from any financial claim against her in that circumstance, a legal remedy considerably more concrete than a modern reader might expect from a legal code nearly 38 centuries old. So what's actually going on in a legal system this old that already has this much procedural detail worked out? Assyriologist Roth's broader analysis of the Mesopotamian legal corpus argues that this level of codified detail reflects a society in which marriage functioned legally primarily as a property and family alliance arrangement between households, meaning its dissolution needed the same kind of clear, enforceable rules that governed any other major property transaction, inheritance, land sale, debt settlement, rather than being left to informal custom or unregulated religious authority. Marriage, under this framework, wasn't primarily a sacred unbreakable bond in the way later religious traditions would come to frame it. It was a contract, and contracts in any sufficiently developed legal system need enforceable terms for both formation and dissolution. Travel east entirely outside the Mediterranean and Near Eastern legal world this video has traced so far, because ancient China developed its own independent, formally codified divorce system, worth including directly because it demonstrates this pattern wasn't confined to a single connected cultural sphere. Historian of Chinese law, Kathryn Bernhardt, whose research on Chinese marriage and family law across dynastic history has been published extensively, including her comparative work on Qing dynasty legal practice, has documented that Chinese legal tradition, formalized in detail under the Tang dynasty legal code compiled around 653 CE, and substantially carried forward through subsequent dynasties, including the Ming and Qing, recognized a specific enumerated set of legal grounds under which a husband could divorce a wife, known as the seven outs, or qichu, covering conditions including a wife's failure to bear a son, infidelity, disobedience toward her husband's parents, jealousy, serious illness, excessive talkativeness, and theft. Bernhardt's research is direct about a structural asymmetry worth naming honestly here, because it echoes a pattern that will recur across several legal traditions covered in this video. The qichu grounds for divorce were formally available to husbands, not wives, reflecting Chinese legal tradition's broader patrilineal structure, in which a wife who left her husband's household without his consent held little independent legal standing to do so. Bernhardt's research documents an important qualification, however. One, that complicates a purely one-sided reading. Tang and subsequent dynastic law also recognized three specific protections, known as the three limits or sanbaku, that barred a husband from invoking the seven outs under certain circumstances, including cases where a wife had no family to return to, where she had observed the required mourning period for her husband's parents, or where the family's fortunes had improved since the marriage began and she had shared in its earlier hardship. A set of protections legal historian Bernhardt's research describes as functioning in practical effect as an early codified limit on unilateral divorce specifically designed to prevent a husband from abandoning a wife purely for convenience, once circumstances changed in his favor. Consider what that combination actually reveals about Chinese legal thinking on divorce, because it adds a genuinely distinct data point to the comparative picture this video is building. Unlike Mesopotamian law's roughly symmetrical financial penalties applying to either spouse's fault, and unlike the more balanced access this video will document shortly in ancient Egypt, Tang Chinese law built an explicitly asymmetrical system, formal divorce initiation reserved for husbands, but paired that asymmetry with specific codified protections limiting exactly when and how that unilateral power could be exercised. A third distinct legal architecture for handling the same underlying problem. How a legal system decides, in writing, exactly when and how a marriage can end. Bernhardt's broader research also documents that beyond the husband-initiated Chichu system, Chinese legal and social practice recognized a separate category called Hili, mutual agreement divorce, in which both spouses consented to end the marriage without either party needing to invoke specific fault-based grounds. A mechanism that persisted alongside the fault-based system across multiple dynasties, and that Bernhardt's analysis of surviving legal case records suggests was used with some regularity in practice, further complicating any simple narrative that pre-modern Chinese marriage functioned as a purely one-directional, husband-controlled institution with no room for negotiated exit. Bernhardt's research on surviving Qing dynasty legal case files adds a further layer of practical detail worth including, since formal legal codes and actual litigated practice don't always align perfectly. A pattern this video has already flagged and will continue to flag across other legal traditions. Local magistrates handling marriage disputes, according to Bernhardt's analysis of these case records, frequently exercised considerable discretion in practice, sometimes brokering informal settlements between families rather than strictly applying the enumerated Chichu grounds, and sometimes extending sympathetic treatment to wives seeking to leave abusive or genuinely unworkable marriages, even where the formal legal code offered them no direct, named pathway to initiate divorce themselves. A pattern of practical, case-by-case flexibility operating underneath a formally rigid legal structure that recurs in one form or another across nearly every legal tradition this video examines. Return now to ancient Egypt, because this is where the evidence gets even more specific and even more surprising in terms of who actually held legal power to act. Egyptologist Janet Johnson of the University of Chicago, whose research on women's legal status in ancient Egypt has been published extensively, including her widely cited analysis of Egyptian marriage and divorce documents, has studied a remarkable body of surviving legal papyri from the site of Elephantine, an island in the Nile near modern Aswan, dating primarily to the 5th century BCE, during the period of Persian administration over Egypt, when a community of Jewish soldiers and their families lived at the site and left behind an unusually well-preserved archive of everyday legal documents. Johnson's analysis of these Elephantine papyri, along with earlier and later Egyptian legal material she has studied across her career, documents marriage contracts that explicitly specify divorce terms in advance, including detailed provisions for property division, and critically, documents that either spouse, husband, or wife could initiate divorce under Egyptian legal custom, with the papyri recording actual cases of women doing exactly that. Johnson's research on the Elephantine archive is specific enough to include actual named individuals and actual case details, rather than only general legal principle. One frequently cited contract from the archive, involving a woman named Mibtahaya, documents a marriage agreement with explicit provisions covering what would happen to jointly held property in the event either spouse chose to end the marriage. And separate surviving documentation from the same archive records a woman named Tamet initiating divorce from her husband under her own legal authority, with the resulting settlement recorded in the same kind of careful legal detail Johnson's research finds throughout the archive. These aren't isolated or symbolic cases plucked from theoretical legal commentary. They're actual, dated, named legal transactions conducted by ordinary people, soldiers, and their families, rather than royalty or elite nobility, which is part of why Johnson's research treats the Elephantine archive as such valuable evidence. It documents how divorce law actually functioned in the daily legal life of ordinary Egyptian and Egyptian-adjacent communities, not merely how legal theorists or religious authorities described it in the abstract. Johnson's broader research across earlier and later periods of Egyptian legal history finds this pattern of relatively balanced spousal legal capacity, extending well beyond the specific Elephantine community, documented in earlier Egyptian legal material dating back into the New Kingdom period, suggesting the pattern reflected broader Egyptian legal custom rather than a localized exception tied only to the specific Jewish community at Elephantine. Johnson's research is specific about a detail worth naming directly as a pattern interrupt here. Ancient Egyptian women, according to the surviving legal and documentary record, Johnson has analyzed across multiple archives and time periods, held a level of independent legal standing, including the right to own property independently of a husband, to enter contracts in their own name, and to initiate divorce on their own legal authority. That was unusual not only by ancient standards generally, but by the standards of many considerably more recent legal systems, including English common law for much of its history, a comparison this video will return to directly later. Here's the disturbing part, and it's disturbing specifically because of how sharply it contradicts a common modern assumption about linear historical progress. If Egyptian women in the 5th century BCE held independently documented rights to initiate divorce and control property, and English women, more than 2,000 years later, did not hold comparable rights until specific 19th century legal reforms. Then the assumption that women's legal autonomy has moved in one steady upward historical line is directly contradicted by the primary source record. Legal rights, at least around marriage and divorce specifically, were gained, in some documented cases lost, and gained again across very different societies operating on very different timelines. Push forward now into Rome, because this is where the evidence for genuinely easy, low-friction divorce becomes the strongest and best documented case in the entire ancient legal record. Classicist Susan Trajari, whose research on Roman marriage and divorce published extensively, including her influential 1991 book, Roman Marriage, remains the standard scholarly reference on the topic, has documented that Roman law, for most of the Republic and early Empire, recognized divorce by simple mutual consent or even by unilateral repudiation from either spouse, as fully valid with no requirement to prove fault, wrongdoing, or any specific legal grounds whatsoever. Trajari's research is direct on this point. A Roman marriage structured under the most common legal form known as marriage sine manu, meaning a wife remained legally part of her birth family rather than becoming legally subordinate to her husband's family, could be dissolved by either party simply stating the intention to end it, with no court proceeding, no judge, and in many documented cases, remarkably little social stigma attached, particularly among the Roman elite whose marriages and divorces are best documented in the surviving historical and legal record. Trajari's research is specific about the actual legal formalities involved, because even a system this permissive still required some documented act to mark the divorce as legally effective, rather than a matter of pure private intention. Roman legal and social custom, as Trajari's research documents, generally expected a formal notification, delivered in person, in writing, or through a messenger, using specific customary language indicating the intent to end the marriage, along with the return of the wife's dowry, which Roman law treated as a serious, enforceable financial obligation, regardless of which spouse had initiated the split or why. Trajari's analysis of surviving legal and documentary sources finds that this dowry return obligation functioned as Roman marriage law's closest equivalent to Mesopotamia's fixed silver payments, a defined financial mechanism accompanying divorce even in a legal system that otherwise required no proof of fault at all. Trajari's research documents specific, named historical examples that illustrate exactly how unremarkable this process could be. The historical figure Cicero, the Roman statesman and orator, whose personal correspondence survives in unusually rich detail, divorced his wife Terentia after roughly 3 decades of marriage, and the surviving letters discussing the matter, which Trajari's research analyzes directly, treat the divorce as a significant personal and financial matter, but not as a moral scandal requiring public justification in the way a modern reader might expect. Roman political and social life, as Trajari's broader research documents, routinely used marriage and divorce as tools for building and dissolving political alliances between powerful families, with historical figures marrying and divorcing multiple times across a single political career, a practice recorded without the kind of moral condemnation that later legal and religious traditions would attach to the same behavior. Trajari's research adds one further specific historical case worth naming, because it demonstrates the practice extending to the very top of Roman political life. The Emperor Augustus himself, according to the historical record Trajari's research analyzes, divorced his wife Scribonia and swiftly married Livia Drusilla, who was herself pregnant by, and shortly divorced from, her previous husband at the time. A sequence of overlapping marriages and divorces, conducted at the highest level of Roman political society, with a degree of procedural ease that Trajari's research treats as broadly representative of elite Roman practice generally, rather than as some unique exception granted only to an emperor. Consider what that actually implies about the mechanics of Roman marriage as a legal institution, because it reframes something the modern viewer might assume was always central to marriage: permanence itself. Trajari's research is explicit that Roman law never treated marriage as intrinsically permanent or indissoluble. It was treated, legally, as a continuing state of mutual consent, meaning that the moment either party's consent ended, the legal marriage itself was understood to have already ended, a strikingly different legal foundation from the sacramental, binding until death model that would come to dominate European legal thought many centuries later. Now, here's where the real turn in this video's story begins to take shape. Because everything covered so far, Mesopotamia, Egypt, Rome, spans nearly 2,000 years of legal history and shows a remarkably consistent pattern. Divorce, while never universally easy or free of consequence, was legally recognized, procedurally defined, and in Rome's specific case available on demand to both spouses without requiring proof of fault. The assumption a modern viewer might reasonably carry away from that pattern is that legal restriction on divorce must represent some kind of ancient, deeply rooted human default, gradually loosened over time by modern secular reform. The actual historical record shows something closer to the reverse. Legal historian James Brundage, whose research on medieval canon law, published extensively, including his 1987 study Law, Sex, and Christian Society in Medieval Europe, remains foundational to understanding how European marriage law developed, has documented that the shift toward treating marriage as a permanent, indissoluble sacrament was a specific, traceable theological and legal development within early and medieval Christianity, not a continuation of pre-existing legal norms inherited from Rome or from earlier Mediterranean legal traditions. Brundage's research traces this doctrine directly to specific New Testament passages, particularly teachings attributed to Jesus in the Gospels of Matthew and Mark addressing divorce, which were subsequently developed into formal, increasingly rigid canon law doctrine by church councils and legal scholars across the following several centuries, reaching a fully systematized form by the 12th and 13th centuries under legal scholars, including those working at Bologna, the same center of canon law development already covered in this channel's research on medieval marriage age. Brundage's research traces the specific timeline of this doctrinal hardening with some precision because it didn't arrive fully formed in a single decree. Early Christian communities in the first few centuries CE, according to Brundage's analysis of surviving patristic and conciliar sources, showed considerably more variation and debate on the question than the later fully systematized medieval doctrine would suggest, with some early Christian writers and regional church councils permitting remarriage after divorce, under specific circumstances, particularly in cases involving a spouse's adultery. Brundage's research documents that it was specifically the canon law systematization of the 11th through 13th centuries, developed alongside the broader medieval project of codifying Christian doctrine into formal, universally applicable church law that closed off most of this earlier variation, establishing the strict indissolubility doctrine as settled, binding law across Western Christendom by the time canonists including Gratian, whose influential 12th century legal compilation, the Decretum, became a foundational text of canon law, had finished their systematizing work. That's the causal reversal worth naming directly, because it inverts the assumption most people carry into this topic. Indissoluble marriage wasn't the ancient default that modern secular divorce reform eventually chipped away at. In the specific legal traditions this video has traced through Mesopotamia, China, Egypt, and Rome, comparatively accessible divorce was the older, longer-standing legal norm, and strict indissolubility was the newer, historically specific legal innovation. One that took centuries of deliberate theological and legal development to fully establish across European canon law, arriving on the historical timeline considerably later than the flexible Roman system it eventually displaced. This reframes everything covered earlier in this video. Rome's easy no-fault divorce wasn't some strange historical outlier standing against an otherwise universal ancient pattern of marital permanence. It was within the specific span of Western legal history this video has traced, actually closer to the historical norm across a longer stretch of documented legal time than strict Christian indissolubility ever was, at least measured against the full multi-thousand-year record, rather than against the several centuries immediately before modern secular divorce reform. Push into how thoroughly and specifically canon law closed the door Rome had left open, because the legal mechanics here are worth naming directly. Brundage's research documents that by the high medieval period, canon law had established marriage as a sacrament, meaning it was understood not merely as a civil contract subject to the will of the parties involved, the exact Roman legal logic Treghieri's research documented, but as a binding covenant recognized and sustained by divine authority, which meant no human court, civil or ecclesiastical, could dissolve it once validly formed and consummated. What canon law offered instead of true divorce was something legally distinct: annulment, a ruling that a marriage had never been validly formed in the first place due to some defect at its formation, and separation from bed and board, which allowed spouses to live apart without dissolving the underlying marital bond or permitting either party to remarry. Now here's the disturbing part, because it shows exactly how this theological shift reshaped incentives in ways that had very little to do with morality, and a great deal to do with practical legal strategy. Because annulment required proving a marriage had never been valid, rather than that it had simply broken down, canon law litigation across medieval Europe developed an entire specialized body of legal argument built around technicalities, undisclosed prior betrothals, insufficiently distant degrees of kinship between spouses, claims of coercion at the time of the wedding, precisely the kind of technical, often manufactured legal grounds that historian Lawrence Stone, whose research on marriage, divorce, and family life in early modern England was published extensively, including his influential 1990 study Road to Divorce, has documented English and continental church courts processing in substantial volume across the medieval and early modern period. Stone's research documents a specific, well-known illustration of exactly how flexible this technically inflexible system could become in practice. Worth including directly: the marriage of King Henry VIII of England to Kathryn of Aragon, which Henry sought to have annulled rather than simply dissolved, precisely because canon law offered no other legal mechanism, arguing that the marriage had been invalid from its formation because Kathryn had previously been married, briefly, to Henry's own deceased brother Arthur. A degree of kinship canon law's rules on affinity treated as legally disqualifying regardless of whether that earlier marriage had ever been consummated. Stone's research treats this case as exceptional mainly in its scale and political consequence, since the Pope's eventual refusal to grant the annulment became a direct catalyst for England's break from Roman Catholic authority entirely, but describes the underlying legal strategy, seeking annulment through a technical kinship or prior contract argument, as a thoroughly ordinary legal maneuver that wealthier and better connected parties across medieval and early modern Europe employed with some regularity when a marriage needed to end and no formal divorce existed to end it. Stone's research is specific that these annulment cases functioned in practical effect, if not in formal legal theory, as a kind of divorce substitute for those with the resources and legal sophistication to pursue one, meaning canon law's supposedly absolute prohibition on divorce was, in documented practice, considerably more porous for wealthy and legally connected parties than the formal doctrine suggested. Push now into a genuinely parallel legal history running through the same centuries canon law was closing its door, because Jewish legal tradition maintained an entirely separate, continuously operating divorce mechanism throughout this entire period, worth tracing directly rather than treated as a footnote. Legal historian and rabbinic scholar David Feldman, whose research on Jewish marriage and divorce law has been widely cited in comparative legal history, has documented that Jewish law, rooted in provisions found in the biblical book of Deuteronomy, and developed extensively across the Talmudic period, roughly the 1st through 6th centuries CE, and codified further by medieval legal authorities including Maimonides in his 12th century legal code, the Mishneh Torah, recognized a formal divorce document called a get, which a husband was required to provide a wife in order to legally dissolve a marriage under Jewish law. Feldman's research documents the get's actual legal mechanics in some procedural detail, because the document itself was subject to strict formal requirements. It needed to be written by a qualified scribe, specifically for the couple involved, rather than as a generic template, witnessed by 2 qualified witnesses, and formally delivered by the husband or his authorized agent directly into the wife's possession, with the marriage considered legally dissolved only once that delivery was properly completed. Feldman's research documents that Talmudic-era rabbinic courts developed extensive case law addressing exactly what could go wrong in this process. Disputed authorship, questions about a scribe's qualifications, disputes over whether delivery had been properly completed, producing a genuinely sophisticated body of procedural law surrounding the get that predates by many centuries the kind of formal divorce procedure many people assume is a distinctly modern legal invention. Feldman's research documents that while the formal legal authority to initiate a get rested with the husband under classical Jewish law, a structural asymmetry with real documented consequences this video will address, directly rabbinic courts across the medieval period developed and enforced mechanisms, including the power to compel a reluctant husband to grant a get under specific documented grounds, cruelty, refusal to provide financial support, certain occupational or health circumstances. That gave wives real, court-enforceable legal recourse considerably more robust than what parallel Christian canon law offered women seeking to exit an unworkable marriage during the same historical centuries. That structural asymmetry is worth being direct about rather than glossing over, because it connects to a real and still relevant modern legal issue. The requirement that a husband personally grant the get, rather than a court simply issuing a dissolution independent of his cooperation, created what's known within Jewish legal tradition and modern family law as the agunah problem, referring to a wife whose husband refuses to grant a get, leaving her unable to remarry under Jewish law even after a civil divorce has been finalized. Feldman's research and subsequent modern Jewish legal scholarship document this as a genuine, historically persistent limitation within an otherwise comparatively flexible system, one that rabbinic authorities across many centuries actively worked to mitigate through court-ordered compulsion mechanisms, but never fully eliminated. Push into the Islamic legal tradition next, because it offers a third parallel case running through these same medieval centuries, with its own distinct legal architecture. Islamic legal historian Judith Tucker, whose research on Islamic family law across multiple regions and centuries has been published extensively, has documented that classical Islamic jurisprudence, developed across the major legal schools beginning in the 8th and 9th centuries CE, recognized multiple distinct legal pathways for ending a marriage, each with different procedural requirements and different implications for financial settlement. Talaq, a form of divorce initiated unilaterally by a husband through a specific verbal or written declaration, represented the most straightforward pathway, though Tucker's research documents that classical jurisprudence across most legal schools built in specific procedural requirements, including waiting periods and in many formulations a requirement that the declaration be repeated across separate occasions before becoming final, designed explicitly to prevent impulsive or purely emotional dissolution of a marriage. Tucker's research documents the specific structural logic behind that waiting period requirement, known as the Ida, a period generally set at 3 menstrual cycles or a fixed number of months, during which the couple remained legally married while separated, with a documented dual purpose: establishing whether the wife was pregnant, which would affect questions of paternity and financial support obligations, and providing what several classical legal commentators, according to Tucker's research, explicitly described as a cooling-off period intended to allow reconciliation before a talaq declaration became legally final and irrevocable. This mirrors, through an entirely independent legal and theological tradition, the same underlying instinct found in Chinese law's Sambuk protections and Jewish law's rabbinic compulsion mechanisms. A recognition that a formally simple divorce procedure, if left completely unstructured, risked producing outcomes a legal system's own framers considered too impulsive or unjust, and a resulting willingness to build procedural friction back in without abandoning the underlying principle that marriage should in fact be dissolvable. Tucker's research documents a second, distinct pathway available specifically to wives: khula, a form of divorce initiated by the wife, typically involving her returning some or all of the dower payment she had received at marriage in exchange for the marriage's dissolution. A mechanism functioning, in practical legal terms, as a wife-initiated buyout of the marriage contract. Tucker's comparative research across multiple regions and historical periods documents that khula proceedings, unlike a husband's unilateral talaq, generally required either mutual agreement or, in cases of dispute, a ruling from a tuti, an Islamic judge evaluating the wife's stated grounds, which historically could include cruelty, failure to provide financial support, or a husband's absence comparable in structure and function to the fault-based grounds Mesopotamian and Egyptian law had already recognized millennia earlier. Tucker's archival research on Ottoman-era Islamic court records specifically, the same body of court documentation referenced elsewhere in this channel's research on historical legal practice, documents that khula petitions appear with real regularity in surviving case files from multiple regions and centuries, indicating this wasn't a rarely used theoretical option, but an actively functioning legal pathway wives used with some frequency when a marriage had become unworkable. A finding Tucker's research treats as an important corrective to the assumption that women's ability to exit a marriage under classical Islamic law was purely nominal or symbolic. Consider how deliberately layered this comparative picture actually is. Once Jewish and Islamic legal tradition are placed directly alongside the canon law history already covered, because it demonstrates something important about the specific historical claim this video is making. The shift toward marital indissolubility wasn't a universal human legal development that every major legal tradition eventually arrived at independently. It was, according to the documented legal history traced across this video, a specific development within Christian canon law, occurring during the same centuries in which Jewish and Islamic legal traditions, operating in the same broad Mediterranean and Near Eastern world, maintained continuously functioning, if imperfect and asymmetrically structured, divorce mechanisms throughout. Push toward the most extreme documented case of legal restriction this video will cover, because English law after the Reformation represents a genuinely unusual historical outlier, even within the broader canon law tradition already described. Legal historian Lawrence Stone's research on English marriage and divorce history documents that England, following its break from Roman Catholic canon law jurisdiction during the 16th century Reformation, under Henry VIII, developed one of the most restrictive divorce regimes in documented European legal history, arguably more restrictive in practice than Catholic canon law's own annulment-based workaround had been. Stone's research documents that from the mid-17th century through 1857, full civil divorce with the right to remarry was available in England only through a private act of parliament, an extraordinarily expensive, slow, and socially exposing legal process requiring an individual petition debated and voted on by the full legislature, meaning Stone's own data, drawn directly from parliamentary records, shows that fewer than 400 such divorces were granted across the entire period from the mid-17th century to 1857, in a national population numbering in the millions. Stone's research documents the actual procedural mechanics of a parliamentary divorce in some detail, because the cost and exposure involved were substantial enough to explain, on their own, why so few were ever pursued. A petitioner, in practice almost always a husband, first needed to obtain a judgment in the ecclesiastical courts establishing a wife's adultery, then pursue a separate common law action for damages against the wife's alleged lover, and only after both of those proceedings had concluded could a private bill be introduced in the House of Lords, debated, and voted upon, with the entire multi-stage process according to Stone's research, typically costing a sum equivalent to many years of an ordinary laborer's wages, placing it entirely beyond reach for all but the wealthiest petitioners. Stone's data documents that the structural cost barrier meant parliamentary divorce functioned in practice almost exclusively as a mechanism available to wealthy men seeking to divorce a wife for adultery, with the reverse case a wife seeking to divorce an adulterous husband, succeeding only a small handful of times across the entire 2-century period Stone's research covers, reflecting the same gendered asymmetry already documented in this video's earlier discussion of Chinese and Jewish law, though considerably more severe in England's specific case. Here's the pattern interrupt worth naming directly. This specific English legal regime, not some vague ancient tradition, is the historical source of much of the modern popular assumption that pre-modern marriage was universally close to unbreakable. Stone's research is explicit that England's parliamentary divorce system was a genuine historical outlier, more restrictive than contemporary Catholic canon law's annulment practice, more restrictive than Jewish get law, more restrictive than Islamic khula and talaq, and dramatically more restrictive than the Roman legal system that had governed the same broad Western legal tradition roughly 15 centuries earlier. The popular image of marriage as historically airtight and unbreakable turns out to be drawn disproportionately from one specific, unusually restrictive legal regime, generalized backward across all of history, as though it represented some universal ancient default, when the actual comparative legal record this video has traced shows something considerably more varied. The Matrimonial Causes Act of 1857 finally transferred divorce jurisdiction in England from Parliament to a newly established civil court, according to Stone's research, dramatically increasing the number of divorces granted. Though Stone's data shows the 1857 Act still required proof of fault, generally adultery, and applied markedly unequal standards to husbands and wives, with a wife required to prove adultery combined with additional aggravating factors, cruelty, desertion, that a husband was not required to prove. A legal asymmetry that persisted in English law for decades after 1857 before further reform gradually equalized the grounds. Stone's research traces that gradual equalization forward across the following century, documenting incremental legal reforms, including the Matrimonial Causes Act of 1923, which finally equalized the adultery-only standard between husbands and wives, and subsequent 20th century legislation that slowly expanded the list of recognized grounds beyond adultery alone. Even so, Stone's research is clear that England did not move to a genuine no-fault divorce standard, allowing dissolution based simply on an irretrievable breakdown of the marriage without requiring either party to prove specific wrongdoing, until reform legislation passed in 1969, meaning the full journey from parliamentary-only divorce to modern no-fault divorce in England spanned more than 3 centuries of incremental legal change, each stage of which Stone's research documents in direct comparison against the considerably more flexible systems this video has already traced across Mesopotamia, China, Egypt, Rome, Jewish law, and Islamic law, several of which had already reached comparable levels of practical accessibility many centuries, in some cases millennia, earlier. Now zoom out across the full 4,000-year span this video has traced, because the actual shape of that history looks almost nothing like a simple line running from ancient restriction to modern freedom. Mesopotamian law, nearly 4,000 years ago, had codified financially defined divorce procedures available to both spouses under specific documented conditions. Ancient Chinese law, developed independently on the far side of the Eurasian landmass, built its own formally enumerated grounds and its own protective limits on when those grounds could be invoked. Egyptian legal practice, more than 2,000 years ago, documented women independently initiating divorce and controlling property with a degree of legal autonomy that wouldn't be matched in English law for another 2 millennia. Roman law, for most of its history, treated divorce as available on demand to either spouse without requiring proof of fault. Then, beginning roughly 1,000 years ago and fully entrenched by the High Medieval period, Christian canon law introduced marital indissolubility as a specific theological and legal innovation. While Jewish and Islamic legal traditions, operating across the same centuries in the same broad region, maintained their own continuously functioning, if imperfect, divorce mechanisms throughout. England then pushed considerably further than even canon law's own restrictions, producing, for roughly 2 centuries, one of the most restrictive divorce regimes in the entire documented historical record. A regime so restrictive that its own retrospective shadow is likely responsible for a large share of the modern assumption this video opened by directly challenging. Line all 6 of these legal traditions up side by side, rather than treating any single one as representative of the past generally. And a genuinely different picture of marital history emerges than the one most people carry by default. Legal restriction on divorce, rather than being humanity's ancient default starting point gradually loosened by modern reform, looks instead like a specific, comparatively late historical development, arising within one particular theological tradition, reaching its most extreme form within one particular national legal system, during one particular 2-century window, and running the entire time alongside other major, well-documented legal traditions that never adopted anything close to the same restriction at all. Modern no-fault divorce, introduced in most Western legal systems across the mid to late 20th century, including California's landmark 1969 Family Law Act, often popularly framed as a radical, unprecedented break from ancient tradition, looks considerably different once measured against this full comparative legal record. Judged not against the narrow slice of English parliamentary era restriction, but against the full 4,000-year span this video has actually traced. No-fault divorce reads less like an unprecedented modern invention and more like a return toward a legal logic, marriage dissolvable by the consent, or in ancient Rome's case even the unilateral will of the parties involved. That Mesopotamian, Chinese, Egyptian, and Roman law had already worked out in varying forms, thousands of years earlier. Somewhere in the storage rooms of the Louvre in Paris, the Hammurabi stele still sits, its carved cuneiform text specifying exactly what a Babylonian husband owed a wife he chose to divorce. Written and enforced roughly 37 centuries before anyone in Europe would seriously entertain the idea that a marriage might legally end without an act of parliament, a scandal, or a lie about undisclosed kinship told to a church court, standing as a quiet, carved-in-stone rebuttal to the assumption that permanence was always the rule and freedom to leave was always the exception.